Dear participants, very good evening. This is Dr. Bennett. We welcome you all for the seventh day International Research Methodology Workshop on Citation Practices, Patents, Intellectual Property Rights, and Proposal Writing for Funded Projects, organized by Research and Development Cell, IITM, Integrated Institute of Disaster Management, followed by State Islamic University of Madrasa, Indonesia, and in collaboration with various departments of sociology colleges from Tamil Nadu to Punjab. And we are very happy to invite you for this beautiful day. Today is the seventh day, and so welcoming you all for this day. And tomorrow we have one more session, patents. So yesterday, a resource person gave some in-depth analysis of informations regarding what do you mean by patent and how we are getting seated in the name of patent. And today we have another legend in the from the Department of Social Work, and Dr. Arul sir. Earlier, he has been a resource person in one of our events, and we got a good, beautiful, what was that, feedbacks uh, from his presentation. And such a great legend in the field, and he is working as an assistant professor in the Department of Social Work. We are from sociology domain, and but we used to give equal opportunity to all the domain people. So this time you can see the faculties from yesterday, faculties from English department, sociology department, commerce department, and research analyst. So we have given chance to many people. Why? Because no, it is not only the domain oriented. We are multidisciplinary approach. As per the NAC purpose, as per the new protocols, we are supposed to reach towards a new domain called multidisciplinary approach. So we are doing our level best. Today's resource person is Dr. Arul Octovin Krisaraj sir, and he is working as an assistant professor in the Department of Social Work, Sri Ramakrishna Mission Vidyalaya College of Arts and Science, which is affiliated to Bharatiya University, Coimbatore, Tamil Nadu. And today he will be taking the classes. As like yesterday, we are locking the meeting till 7:40 to 7:45, and then we will be opening the meeting for the participants for the healthy discussion. Yesterday, we really enjoyed the discussion time, nearly about 20 minutes. We had a good discussion time with the resource person, and even she also happy the way that we interacted. So it is not about one-way track; it is two-way track. But maybe knowingly, unknowingly, some of us unmuting ourselves and talking something which disturbs the entire class. So we don't want to disturb entire people because of one single person. That is the only thing we're locking the meeting. Apart from that, no personal reasons behind that. Hope you are following the rules and regulations very strictly. Today is seventh day. 75 percentage attendance is mandatory for getting your certificate. I'll repeat the word. 75 percentage of the attendance is mandatory for getting your certificate. Now you may ask a question, sir, how you are taking the attendance? We are not getting any link. That is why we told you very clearly in the Google form itself, you have to log in with your name and ID. So we came to know many people given the name HP, Xiaomi, Apple, iPhone. So we are marking absent for those people, but the people who are really maximum people are doing their level best. So this is not a place to blame everyone. Maximum people obeyed what we have told because simply we can't spend more time in by taking attendance in the open forum, and Google form also will not work in all other aspects because we have better as well as better experiences while using Google form. So your entire attendance has been monitored by the technical team. We have a strong technical team here, so they are checking everything accordingly. Seriously, we are speaking that we are at least 75 percentage of the attendance should be there to getting your certificate, and we are getting a good number of collaborators for our upcoming event, which I have told you last time that we are going to have international research methodology, sorry, faculty development program and faculty exchange program with three international universities and Indian universities. So those who want to collaborate for this international event with your department or with your college wise, you are most welcome to join with us. Definitely, we will do the needful. Now the floor is open to Dr. Arun sir. Uh, Open to you, sir.
Okay. Thank you, sir. So am I visible? Am I audible too? I
Yes, you
hope.
are visible. Yes, you are visible, sir. Visible.
Okay. Now I will be sharing my slides. Is it visible, sir?
Not visible.
Sir, the slides
No, sir. Ah, yes, now visible.
is visible. Yeah. Okay. So thank you, Dr. Bennett Rajadurai, for introducing me as well as the organizers team also. Very good evening, all of you, for this your seventh day international workshop. Today, the session is going to be on intellectual property rights in terms of copyrights, technology transfer legal frameworks for protecting outreach, research output, copyright issues, ownership rights, and mechanism for technology transfer. Today, the sessions I will be going to talk about what is property, intellectual property rights, and then the importance of intellectual property rights and copyright issues, and then the legal laws for intellectual property rights, and then technology transfer. These are the things we're going to be one by one. We are going to see today. So the slides are visible now. Is moving. Just want to confirm.
Yes, sir. It's moving, sir, and it's completely visible. You also
Okay.
visible, sir.
The property. The first very important one is when it's come to property. That we are mainly focusing on intellectual property rights. So the what is property? The which is can be owned, which anyone can own. All those things called as a property. So this property also can be divided into. We can divide this property into. There are two mainly: corporate property and incorporeal property. The corporate property, all of you might be. Every one of us having our own properties like land. We might having car, building, money. There are so many things when it's come to corporate property. So every individual we might have having the corporate property that also can be classified into movable and immovable. Movable mainly we can call this like money, car, even sometimes even building also movable. Properly. So the immovable is like land. Land cannot be movable. So corporate property. So what is incorporeal property? There our today's section starts. So incorporeal property that's mainly refers to the immaterial that is also called the intangible property like footprint, patents, copyright, trademarks, so many things like we are going to see today. So with this, we mainly focusing on what is intellectual property. That's what we already seen this incorporeal property. That this intellectual property start. Intellectual property that can be categorized as the property that include intangible creation of the human intellectual. What can be creation of the minds of individuals, any human being, such as invention, literary, artistic works, designs and symbols, names and images used in the commerce, all those can be called as intellectual property. So now these intellectual property, why it's come to the relevance and it's come to rights. So the rights. So the rights before going to that, the types of intellectual property we are saying like for each and every intellectual property which has been given in India, especially in India, we are saying the world level also, global level also, we have intellectual property rights. This can be classified into different types. So it's complete copyright. Every intellectual property we have it in Act in India. When it's come to India, every intellectual property have its own Act. When it's come to for copyright, we have a Copyright Act 1957. For Patents Act 1970. Trademarks Act 1999. As well as for GI, Geographical Indication. For that, Geographical Indication of Goods Registration and Protection Act 1999. And then layout, for instance, come to IC, designs for design, layout design for IC, the integrated circuit, semiconductor integrated circuit layout designs act 2000. For unclothed information, there is no such act that also, and the protection of plant varieties and farmers right, PPV and FR Act 2001. So now we are going to see exactly what is intellectual property. IPR, we call this IPR. These are the rights acquired by the owner of an intellectual property. So we already know intellectual property means the creation of mind, the creation of mind. So these also can be covering mainly the patents, copyright, trademark, industrial designs, geographic indication, layout designs of integrated circuits, and disclosed information. This mainly trade secrets. It can be any form of trade secrets and new plant varieties. There's a new ones added in 2001. So these things mainly become going to be like intellectual property. Right? These are the covering different properties, rights. And then The main purpose of the intellectual property rights, the law. They have a certain law. We already seen there are several law that will be seen in detail in the end of before the end of the today's session. So, in order to encourage the creation of wide variety of intellectual goods and strikes the right balance between the interest of innovators and wider public interest. This is the main thing when it's come to the main purpose of intellectual property law. That is also legal rights. So the why is IPR, intellectual property rights, in order to provide an incentive to the individual for their new creations. So every individual have their own creation. That's has been like it has been acknowledged as well as it has been given initiative as well as recognition. So to recognize the creator and then inventors. For invention also that can be this intellectual property rights can be used as well as to make available genuine and original product. This is also another important. Says mainly intellectual properties is mainly the genuinity. That's what this intellectual property rights. So now already we have seen this is mainly covering the patents, copyright, trademarks, industry designs, GIs, layout designs, and trade unclosed the trade secrets and new plan variety. These things we are going to see one by one. Before that, I just give you some overview about like what is copyright. Then this thing will be in detail. Copyright can be in form of artistic, literary, musical, and dramatic creations come into existence as soon as the work is created. The duration for this copyright can be given the life of the author till my end of my if I own my copyrights for my own writing books for if I already published a book that I'll be seeing. So till my end of the last the life till my end of my life plus 60 years the copyright can be own as well as copyright. Then Copyright Act 1957, according to 1957. For trademarks, what is trademarks? So these are not part of your thing. It's mainly we can just give overview about what is this trademark. Trademark is a visual symbol which may be word signature, name, device, label, numerical, and combination of colors used by one undertaking on goods and services is mainly we have seen these trademarks in the goods and services, the commercial aspect only we are seeing. Is also that other article commerce to distinguish it from another similar goods and services or services originating from the different undertaking. At the same time, any name which is not unusual for trade to adopt as a mark, or same time a device, a symbol, or monogram. It's a same time is safe of goods, combination of colors, even a single color contestant in combination with word or device, duration of and a trademark protection forever. Maybe the renewal every 10 years duration. For industrial designs, we already seen this refer to external features or safe configuration patterns and compositions of lines or colors applied to any article, whether 2D or 3D forms. And then fundamental testing aspect of a useful article or industry. At the same time, this visual form of products is also can be not only technical. When it's come to technical, it can be called as like a for patent. For a not distinct features, that's called as a trademarks. That will be seen the examples also. Now you see the Coca-Cola is a very famous product. So you see how is like we were seeing the copyright as well as trademark. See, look at that every many of us might be drunk this Coca-Cola. So you see the brand name. The brand name, the logo. At the same time, it has a trademark protection as well as logo, copyright protection, and then recipe is inside trade secret. That's an undisclosed information. Also, is there portal safe. That is a design protection as well as trademark protection. Also, that's also we can see in this Coca-Cola this product. So next, you see, see that's what we can see. The ornamental aspect of the article consists of three main features. Look at that bottle. That's what the clear information is given. So mainly the last point I just wanted to say, the protection will last in the initial 10 years. After which it can be usually renewed or in most cases up to 15 years. 10 plus 15 years can be given for this trademark And next, you see that different symbols might have seen. This first one is for copyright. Second one is for trademark. So see, look at here. If it C is copyright one, R is trademark, TM means trademark. So R means registered trademark. If it's TM means unregistered. Even without register also anyone can use this TM. But when we are using R, so only the registered products only commercial goods and services can be used as a R for them. So R, if you see any product, you can see is a R in the symbol is the end of the thing. We can see is with Coca-Cola also you see the bottle Coca-Cola on the top of the down bottom of this Coca-Cola written. You may see this R. So that means this is a registered trademark. So why we want to discuss about this thing? Because we want to know the intellectual property rights. So these things, all these things we want to know. And see, look at this image. You can see this image. If it's trademark, the symbol is the obviously the rate. That's what's the main important. Many of us like will go for the product. The product which is like very important. Like we may not go. So many of us might be have using like any product like even clothes, even for using the daily usage, the mobiles. We'll go for it. That's what the product like even everything intellectual property rights. Then geographical indication GI. GI is identified is mainly will use as like agriculture or natural or manufactured good and associated with the territory, region, and locality. So GI indication we used to see here, often used to hear this product maybe got it like GI indication. And I think many of Indian states might be like different than the native products already got GI indications. And Tamil Nadu also there are different products also got GI indication. That's all we can apply for and then get it like that's what's mainly focusing on natural as well as agriculture manufactured good associated with the particular territory, region, and locality. So that we can go for further production as well as increase the economical or commercial aspect. And then GI gives the protection to the group of people or association. That's what mainly association involved in the protection of the product using traditional skills or knowledge. That's what is about GI. If any product got GI indication, it has its own features. So that's what, and then its manufacturing goods should be produced, processed, or prepared in the particular territory. So it cannot be, produced in other territory. And this gives, for example, many of them have heard about Kodaikanal. Kodaikanal, this GA indication is also there. And this gives a special quality of the product due to the geographical climate, environment, specific manufacturing, farming, or skill, tradition, and other characteristic attributes to origin. It consists of the name of the place of origin, originate from the definite geographical area. That's what it's mainly given. Another thing is there are examples like Darjeeling tea. We had about like Darjeeling tea. This Darjeeling we can be only produced in the Darjeeling alone. That's Kanjipuram silk saree. It's famous Kanjipuram. Silk saree also is very famous. It's got its own geographical indication. Another than collaborate chapels as well as Tirupati Lattu. Many of us know about like Tirupati Lattu. Tirupati is famous for the Hindu goddess, God, as well as the Lattu also, the Nagpur orange. Whenever you're traveling, we used to buy when we are traveling through Nagpur also, we must always this Nagpur orange always has own GI tag. Then plant varieties also it has its own intellectual property rights also can be added. So new and novel plants and plant varieties are protected across the globe either through the patents or through the sui generis system. And the TRIP's agreement states that there shall be a patent protection or sui generis protections of the plant and varieties. This for just for information. Another thing is mainly it has own how these plant varieties are going to become intellectual property rights to the Act of the Protection of the Plant Varieties and Farmers' Rights Act 2001. And another thing is this Act also aims to establish the effective system in terms of protecting the plant varieties, the rights of the farmers and plant traders, and to encourage the development of new varieties of plant. With this, Now, very important one. I think this is also connected with the tomorrow's session. Also, I mainly little bit I touch upon this pattern. So the pattern, also the commercialization, all this. We have a next session. You have a tomorrow session. You are also mainly focusing on patterns. Today's sections we are going to cover mainly on copyright as well as technology transfer and the legal aspects of when it's come to this IPR. So that's what you are going to see today. Now, I hope I'm audible too. So now we'll move to the patent. What is patent? Patent
Yes,
is mainly and exclusively.
you are
Am I
audible, sir. You
audible?
are audible.
Sir?
Yes, sir. You are audible.
Okay, okay, thank you. The patent is mainly it's a exclusively monopoly right. So who is this granted by the government of India? He can apply, and then we can got like the patent can be given for our invention. So individual or group of people who is mainly working for this patent, they may get it for their invention through their creative ideas, creative minds through that we can granted by the government of India application. So to the it can be given to the inventor or his her assignee can be given not only to me. If I apply for my own invention, the government of India, not only me through my assignee also you can apply also as a territorial right. The territorial right. So this patent is mainly given to only the government of India is given only to the territory within our country alone. It's not for other country. It's live with the disclosure of invention to the government as well as the patent duration is 20 years from the date of filing in the Patent Act 1970. From the date of application is very important when it's come to duration of it. Once the patent is granted by the government of India, it can be given from the when the date of filing. The reason behind is sometimes even today we are filing for the patent. Tomorrow the next person, another person who got your maybe got they can file the same thing in order to avoid this problem. So that's why the filing, the duration for the patent given from the when the date of filing the patent. And then the value for patent protection is mainly the patents may be granted for inventions, any field of technology, from an everyday kitchen utensils to the nanotechnology chip. So we can get the patent for many things like that can see. So to next section you can see in detailed manner, but today a little bit I can touch upon this patent protection. That's what I say. Even patent can be get it for even everyday kitchen utensils to even nanotechnology chips, the minute one also that can be even patent can be patented. So invention can be produced such as the chemical, for example. We are from the mainly from I think I hope many of us from Indian social science background. Even though, for example, the chemical compound or a process, this is a invention. For example, the process of producing the specific chemical compound. So the how this chemical compound, the process that can be is an invention that can be patented. Many product, in fact, contain a number of invention. For example, laptop or computer can involve hundred of inventions working together. So not only single, but even multiple also together also we can get it for patent. And then conditions for paternity. A patent is granted to a product or a process that's mainly non-obvious or capable industrial applicability. That's mainly this in which condition this patent can be given. First one is a novelty, genuinity, and something new. Something new which has not been anticipated for the publication any document used anywhere before. The next one is non-obviousness. For an invention to be non-obvious should not be obvious to a person skilled in the particular art or industrial applicabilities. The products are supposed to be it's applicable in day-to-day use or like different process and technical industrial aspect also. The invention for which the patent or client should be capable of industrial applicability. It might be possess some utility. There should be some usefulness. So industrial applicability, when we hear about industrial applicability, it has some useful. That's what in these grounds only these patents can be given. And see the website for these patents. So the patents for this is a WIO, World Level Patent Organization. The website you can check it can be given the access for like different variety informations for the product patents also you can get it. Even the India also we have IP India website also for there. From there you can get the informations about even yeah. So, for example, this intellectual property rights mainly undertaken by the intellectual property rights, patents, designs, trademarks, geographic indication, all those things in the office of the controller of general of patents, designs, and trademarks under the Department of Promotion of Industry and Industrial Internal Trade by the Ministry of Commerce and Industry. At the same time, even copyright has its own office, Copyright Office, the Government of India. So all this we can focus on it. If you want even further reference, even on the websites, it has own all the everything in detail, even up to date. Even the even recently, the Office of the Control of General Patents and Designs and Trademark, even last ninth, it has the new website has been launched for this thing. Is and then mainly the applications, everything is will be digitalized in India. So that's what you keep it in mind. For your further information, your clarification, you can check the website. Can and then this duration of the patent, I already told you in the beginning, if I give the introduction of the patent, the term for every patent granted for 20 years from the date of filing. That's what I told you. In order to further some clarification or confusion over the whose invention is genuine. For that, in order to avoid this confusion only, the data filling application is has been given. Another thing is, however, this applications filed under the national phase under the patent cooperation treaty, the patent can be given different forms that we'll be seeing later. There's a patent cooperative PCT. The term patent will be 20 years in the international filing date according to the PCT. So even it can be filed even your collaborative work. If it's collaborative work with like Indian or like other foreigner, if you're working together, if you're mainly going for like any patent, so that also can be done. Another thing is the law is even that's what I told you. Even the government is day to day updating also. Even this patent system in India is governed by the Patents Act 1970. This amendment is also amended 2005. The patent rules also recently amended 2005. It can be it came to force in 25th of November 2025. This amendment introduced a new chapter related to the adjudication of the penalties and appeal, recent rules. Another thing is these protections said. A patent can be territorial rights. I told you it's mainly the territory within our country. If you are applying for every individual country is the own, the patent rights. So there is no concept of global world patent. So if you are applying for, if you are given for a patent, it cannot be simply go for the global patent. However, the filing application in India enables the applicants to file the corresponding application in some invention in the convention country or under the PCT. That's what Patent Cooperative Treaty within or before expiry of 12 months from the filing date of India. That's what you want to mainly keep it in mind. When you're going for PCT, this should be within or before expiry of 12 months. The patent should be obtained in each country where the applicant requires protection of their invention. So now, with this little bit overview given about patents, now we'll move to what is copyright. So copyright is another important one aspect when it comes to intellectual property rights, IPR. So I hope now the copyright can be the image also is going to be taken. So it can be even from this image also you might get some ideas. What is ideas, ownership, law, patent protection, intellectual content, content also we have to see what is copyright. So before going to copyright, how this copyrights evolved the laws in India through because everything I told you, the types of intellectual property, every intellectual property, right, is its own evaluation, like acts in India. So first one is pre-independence. I just wanted when the Britishers during the British India time, it has been 1847. The first Copyright Act of India has been enacted. Is mainly the copyright term was given for lifetime of author plus 7 years or 42 years. So lifetime of author plus 7 years. But now we have a, you know, lifetime plus 60 years. The Act of 1914 was the first modern copyright law of India. Is also law to include all works of art, literature under the ambit of copyright. It's also replica of English law 1911. So the next is post after independence in India. This Copyright Act of 1957. Even till today, the Copyright Act 1957 works with the little amendments we have. But it says this 1957 after independence with this and Copyright Act of 1957 replaced in by 1914 by the these of the Copyright Act during the British India time. So, the Act also, beside amending the copyright law, also introduced milestone changes such as provisions for setting up a copyright office under the control of, I told you this copyright office, under the control of register of copyright for registering books or any other works of art at all, and also is established a copyright board to deal with the dispute related to copyrights. And this also amended in that's what I told you 1983, 84, 92, 94, 99, 2012 in order to meet the national and international requirement. These main reasons for the amendment of this Copyright Act in 1957 include the bridge the act its conformity with the two well level intellectual property organization treaties concluded in 1996, namely WIP, that is World Intellectual Property Organization Copyright Treaty, and WIP Performance and Phone No Grams Treaty, WPPT. And what is copyright? Now we already see this copyright is an exclusive right of author to copy the literature produced by him or her and stop others from doing so. So the copyright given to the sole author, exclusive right to the concerned author in the form of intellectual property protection granted under the Indian law, that is Copyright Act 1957, in order to the creator of original work of authorship such as literary, that's what you want to keep it in mind. This copyright given to literary, dramatic, musical, artistic works, cinematography, films, and sound recordings. These are the things can be given. Another thing is now will move little bit I have taken from this act, Copyright Act 1957, what is the copyrights of, which are the things mainly focusing on copyrights. Copyright subsists only in the following classes of work: original literary, dramatic, musical, artistic works, cinematograph, films and sound recording. According to section 2O, literary works include the computer programs, tables, and complication, including the computer database. According to the section 2H, the dramatic work includes any piece or from the recitation, choreograph work, entertainment of dumb show, for example, dumb show for this choreograph work also. There is scenic arrangement or acting form, which is fixed in terms of writing otherwise, but does not include a cinematographic film alone. Another thing is section 2P, musical works means consists of musical, including any graphical notations and such work, but does not include any words or any action intended to be sung, spoken, or performed with the music. Another thing is the artistic work. When it's come to artistic work, it can be considered as any painting, sculpture, drawing, including the diagram, map, chart, plan, engraving, or a photograph, whether not any such work possesses artistic quality. Another thing is work of architecture and any other work of architectural craftsmanship. According to cinematograph films means so this copyright 1957 act, you can see everything in detailed manner, the definitions for each and everything which can be copyright also in even any work of visual recording and includes a sound recording accompanying such visual recording can be called as cinematograph. cinematograph shall be considered as including any work produced by such analogs as cinematography, including video films. And then what is sound recording according to session 220 means a recording of sound from which such sound may be produced regardless of the medium or which recording is made or method by which sounds are produced. This is a little bit, you can get to know once you started thinking about any recording sounds also can be the such sounds produced. The medium is not matter. The recording is mainly made or method by which the medium, it's not a matter, but how is recorded. The method that is mainly the sounds are produced also matter. So when it's come to sound recording. Then who's having ownership of copyright work? That's important. The general rule is that a person who creates an original work, if I creating any, if that's what in the beginning, before I told you, well, if I own my own book, for example, if I write or publish my own book, so I have a I will get the copyright work, my original work. So I will be the first owner of the copyright in the work. This rule also applicable in commission's work. The creation of the commission work is also considered the owner of the copyright in the work in the absence of any written agreement to the contrary. So without any agreement is there, if the commission's work also matter. Another important exception I will given when it's come to for this, even though I have produced my own work, original work, but I cannot claim the ownership or a copyright. Copyright is mainly the work is created by an employee in the normal course of employment. In such cases, the employer is considered the copyright owner. So that's why you see, I work in the company where I created my own, work, but that cannot be considered as a, I cannot claim for ownership because I created this for the employee. So that's what. Then in such cases, the copyright given to the employer. That's what the employer is considered as the copyright owner. So excuse me. I'll take break for 2 minutes. Sorry for the disturbance. Okay. So as a owner for the copyright, it depends upon where the work is where this work is produced. Depends upon that only this copyright, so ownership can be given. So next is the term of copyright and related rights. So in case of original literary, dramatic or musical artistic works, 60 years period is counted from the year the following date of the author. Till if I own the originality, the copyright, I'm the owner for the original, if I have own. So I will having till my last birth, till my death, I will have ownership, copyright. plus 60 years period. After the lifetime plus 60 years period, the copyright can be given. In such case, similar claims, this was a 60 years period is counted from the data publication. In terms of cinematograph films, sound recording, photographs, photographs publication, anonymous and anonymous publications, works of the government, or works of an international organization. In such case, if it's a in that case, the 60 years period is counted from the data publication also is there. Another is the performance right. Performance right is from the data performance from the 50 years. Another thing, a broadcast reproduction right is from the 25 years. It is everything is clearly, we can see the Copyright Act 1957. This broadcast reproduction right is from the 25 years from the date of making of broadcast. That's what you see. You need to see the works also from the difference you can see. The data publications as well as when the date periods data publication and the data performance and the data of making the broadcast. Depends upon that only these copyright is also a term also given. So that's what I keep it in mind. For individual, if I'm owning, I still have my 60 years. But these kind of cinematograph photographs or anonymous works, for the government is from the 60 years period. For performance, if I have performance group performance, that's the data performance from the 50 years, broadcast 25 years. Another thing is the rights conferred by copyright. Copyright is a bundle of rights. So that's what why the right is conferred with the copyright. Copyright not only single, it can be bundle of rights also. It can be reproduction, making extra copies. If you want to publish a book, making extra copies also. But if you're publishing a single book, writing a book, but that only not a copyright. If you want to publish, you will not publish only single book all. You publish thousands book or 50, 500 books for making extra copies. Also, once first publication is over, the next, second published. So third, fourth are revised for making extra copies. These are reproductions also. There's a copyright also is that. Another thing is communication. So making any work available for being seen or heard or otherwise enjoyed by the public directly by any means of display. The diffusion for performance, the owner of the copyright has been given to the publicly perform his work. For example, I may perform dramas based on my work and perform at concerts also. And broadcasting, it can be the communicating to the public at large through the wireless means through wire and creating derivative works. It can be cinematograph, film, or sound recording, or respect of the work. See, right now, I'm taking the session on this IPR. This is all being recorded. This also the raw copyright. That also can be think about it. We can think of it's a IPR too. Another thing, adoption for making and cinematograph films are literary work of a literary work. For example, if you're taking the well-known, there is a well-known literary work can be recently produced in Tamil. That's a Ponniyin Selvan. If you are seeing that can be in a literary work has been cinematographed. So that also you see, for that also another thing is translation from one language to another language. For that also copyright matters. See, if I written book, for example, in Telugu, if I want to translate into Tamil, some other one is translating. We see multiple well-known books has been translated from the different language, English or other languages to in Tamil or Indian languages has been translated to that as well. For that only from the publishers we need to get the copyright in authors, publishers for the depends upon the agreement between the publisher and the author. The who wants to translate it also can be get it for the copyright. Another thing is the performance and broadcasting organization rights. The broadcast, if you want to broadcast reproduction, the performance definition. Performance means is any visual causing for presentations made live by one or more performance. Another thing is performer includes when performance means it's any visual causing presentation made live by one or more performance. In which who is performer? Performer includes an actor, even the singer, musician, dancer, acrobat, juggler, conqueror, the snake jumper, a person delivering a lecture, or any other person who makes a performance. So see, whoever involving one on the other, directly or indirectly, do not only the stage, even like indirectly, even behind the stage, they all do together only the performance happening. That's what the performer include when the musician transfer. Who's the person delivering a lecture also including the performer when it's come to the performance, the rights. The performer rights means to make a sound recording or visual recording. This can be only produced by the performer. And then to broadcast the performance, another important is moral rights. Moral rights performance that we'll see later what is the moral rights behind this copyright. The registration or effective registration, copyright registration is not mandatory, first of all. Another thing is it's not mandatory, but at the same time, the work is protected automatically as soon as it's created. So once the work is protected, when it's created itself is the copyright is protected because once you publish the data, publish it. For example, there can be the name itself is to be registered, but why you want to have this? It's not mandatory, but still why you have a copyright act and then there's a copyright office is there under the ministry, trade and commerce. We have what is copyright registration is a prima facie evidence to prove the ownership and date of creation of work. So main reason behind it, if I want to hold the ownership of my creation, my early work, should have ownership and the date of creation. So for the work, for that purpose only, this copyright registration is needed. But I told you the moral rights. Another important, you can see the image. You can see that image. His handy, you can, well-known, famous, you can see Vigyan Bhavan in Delhi. It's well-known. In Vigyan Bhavan, there's a, 19, it's happened in 1957 by the very famous Amarnath Shekhar versus this case, Union of India, 2005. It has been the verdict is, these paintings, a mural, it's called as a mural, has been, removed, dumped in the storeroom without the author permission. It's created by the Amarnath Sehgal, but without his permission has been removed and has been dumped in the storeroom, the Vigyan Bhavan. But in 2005, the verdict came, it should be the court held 5 lakhs compensation and returned to the painting to the him because it's only created by him. As well as for that, even the court is a well-known case. If you want to have an interest about this, you can put like Amarnath Sehgal versus Union of India. So you'll get this well-known case. And then why this moral rights matters? For this behind this case, this moral right is like a right of paternity, the right to claim authorship of work to prevent authors from the claiming ownership. Another thing is right of integrity, the right to have author to prevent distortion, multiplication, other alteration of work that will be prejudicial to the honor of reputation of the author. So in order to that, moral rights also matter. Infringement. Another important one is infringement. There this copyright act source. See, every one of us, like, we believe that we are genuine, we are honest, but when this copyright act works, so we have this act in order to prevent from the infringement. Copying without authorization. That's called infringement. Okay, many of us have been doing both. Section 51 of the Copyrights Act 1957 is mainly described various acts that infringe the copyright of the owner created by the act when any person without license granted by the owner of the copyright or register of copyright are in contravention of the conditions of the license so that it can be granted any condition imposed by the competent authority under the act. See, mainly see the highlight is does anything the exclusive right to do which is conferred upon the owner of the copyright. So also called as an infringement. Another section 51 of the copyright of 1957. It's also permits the profit any place to be used for the communication of the work to the public where such communication constitute an infringement of the copyright in the work unless he or she was not aware about, he had no reasonable ground for believing such communication to the public would be infringement of the copyright. So whether any persons makes a sale or hire to sells or lets for hire by way of trade displays or offers for sales or hire or distributes either purpose of the trade or such extension will affect the fiduciary owner of the copyright. When these things, any one of the form, this fiduciary affect the owner of the copyright, such case there is also infringement also. By the way of trade exhibits public imports into India, for example, from the foreign, if importing certain things without through the trade, except the importing of one copy of any work. Copy of, if importing copy of work doesn't matter, but when it's going to prevent domestic work, use of importer, that also infringement is further. I just wanted to explain this. The explanation of section 51 provides that reproduction of literary, dramatic, musical, artistic work in the form of cinematographic film shall be deemed to be infringing copy. That's another important one. See, in many cases, as when you can see, in the cine industry, these things are often happening. So if people may find that this the story of the particular cinema can be, by my own story. Then often we see in the cases has been filed in terms of infringement. Same remedies. What are the remedies we have when it's come to this for infringement? It's happened. Same as remedies, there are the trademarks, the remedies of the civil and criminal. That's what we'll go to the criminal, like civil code. Criminal code depends upon the infringement level and administrative purpose. We can go for it. Like, the compensations can be given. And the thing is, acts are constituting infringement, which is not mainly focusing on infringement, which is not considered as an infringement. That also we are supposed to be know about it, which is not considered as a why it's not considered as an infringement. The private or personal use criticism review, the reporting of current events and current affairs. See, every day we see in the news media, news channels we see, they are critical about they criticism about what's happening, the events, and then political, the current affairs also sometimes. And the transcendence of incident storage of the work, Francis, and the reproduction of any work for the purpose of judicial reproduction and the purpose of reporting and judicial proceeding, that reproduction of any work. See, for example, by a teacher or people in the course of instruction. See, what right now I'm using, I'm taking certain notes from the reference for my reference. This cannot be considered as an infringement or any part of question to be answered in the examination. For example, here, right, many of us here, research scholars are here, even the faculties from the universities and colleges also here. We are asking the students to write an exam with the questions for the question. So they are answering. They're reproducing from the textbook. So that cannot be considered as a infringement. Infringement. So answers of such questions also cannot be considered as, that's what I wanted to say. Even this cannot be considered as a infringement. And acts of not considering infringement, again further, recording to be heard in public. For example, if we are traveling, we can recording. This cannot be considered infringement. Someone is singing in the public places. So if you are, taking, because someone is performing in the public place, so that is we are recording and uploading in your particular place, cannot be considered infringement. And as for example, as a part of activity of club, a similar organization which is not established or conducted for the profit, mainly the important thing, that particular place is not meant for profit. Those things, the performance, the course of activity in education institution. For example, if the certain performance has been, performed for the course of activity in the education institution, for example, literary, dramatic, or musical work by the staff and students of the institution. If staff and student together as students are producing his own in the educational purpose, in the educational institution purposes, then cannot be considered as an infringement. Another thing is this is another important The case between the Delhi University photocopy case of the Chancellor, Master Scholars of the University of Oxford, and others, presses, Rameshwari Photography Service, and others. See, copyright itself, is you can just go through it. You can see, you know, even if you are taking the photocopy of the books, that's the thing about it, like whether it comes under copyright or not. So Section 52 of the India Copyrights Act 1957 is then interpreted not as a narrow exception. So as a narrow exception, full-fledged defense in favor of educational students and institutions and students. It's mainly 51 is talking about like which other things, but 52 is given such a narrow exception when it's come to defense for in favor of education institution and students in the form of copyright. The term teacher in the section 52 1I is not restricted to an individual teacher, but also it extends through the education institution as a whole. The word instruction is in the section 52 1I is not limited to a lecture in the classroom. Thus, the scope of the provision is not limited to the reproduction of the work by a teacher in the course of lecture, but also include the reproduction for the purpose of making and issuing grades. See, look at here, the sixth point is very important one. For pre-production of the pages from the books from each of the students, whether by a photocopying or copying by hands or clicking photographs for his or own private use, does not amount to the copyright infringement for the which is section of 51. The photocopy is same by the university for the benefit of the student due to certain resource constraint cannot be set as infringement, and the results or effect in both in this the same. Say I have written my own notes that can be taken photography or like photography can be taken or photocopying has been done. That cannot be these things for the welfare of say I'm taking notes for now the session. You are taking notes. Here given for someone's reference. You are taking reproduction. You are taking photo and sharing with others. So that cannot be considered as infringement. Now, with this, we'll cooperate and over. Now we'll move to international inspection and it's going to go related to IPR. What are the IPR thing? Then we'll move to Indian level laws, then intellectual, technology transfer. So now, international level, the Paris Convention, the Berne Convention, Universal Copyright Convention, WIPO, ECT, and WBCT, and TRIPs. These are the things when it's come to IPR, international level, IP related to instruments related to IPR. The Paris Convention, I little bit touch upon. I'll move to the further because we have to have a detailed information about technology transfer. We need to have already we have crossed 1 hour. We have 45 minutes to finish the session. So I try to give judgment to the intellectual technology transfer. So Paris Convention 1883 is mainly focusing on industrial property. The protection of industrial property is concluded on 20th March 1883 for the first and oldest international convention related to the IPR. So if you're talking about IPR without this Paris Convention 1883, we cannot go with the international level. Even for this, we got like various aspects for in our country too, at the global level also. There are 30 articles mainly in the convention in order dealing with industrial properties, dealing the patents, design, trademarks, fault indication, utility models, and the protection. There are 179 members that constitute the Union for Protection of Industrial Property. Under this, Paris Convention is also called as a national treatment, right of priority, uniform rules, and Patent Cooperation Treaty. That's a PCT. It's a concluded in 1970. Look at here, 1883. Now this one is a Patent Cooperation Treaty 1970. It's mainly focusing on the patent protection internationally for their inventions and help patent offices with their patents granting decisions for facilitating public access to the wealth of the technical information related to those inventions. So, for example, these patents only given to the particular country. If you want to going for patent in India, you can Indian government only given to the patent. But at the same time, you can go for like international level. There's no called global or world level patent, but this patent cooperative treaty is mainly protecting the patent. It gives the protections for the patent. But at the same time, it's also filling one international patent applicable application under the PCT applicable simultaneously seek protection in invention to the large number of countries. So it has PCT has its own 157 the countries as a member countries. So it can be applicable, can be simultaneously seek protection. See, if I apply for my own patent, not only my country, even simultaneously can be applicants can be simultaneously seek the protection from the different country because PCT has its own large members of countries 157. National single patent applications with national phase within 30 to 31st months of earliest period date. As focus, patent filing in the Paris Convention versus PCT. So the difference between this patent, filing, PCT application cost 3 to 4 lakhs in Indian rupees. But Paris Convention is about like 1 to 2 lakhs. Uh, but PCT beneficial if you see get patent in the large number of countries in one go. Paris Convention is beneficial if you want to protect limited number of convention. You want to have this for your product patent is mainly focused on only in the particular country in a country or large number of countries, then we'll go for PCT or Paris Convention is mainly the limited number of countries protection, not only in India as well as we go for further countries also. This Paris Convention can be we can apply through. Another thing is the Paris Convention. Next one is the Paris Conventions for literary and artistic work, 1886. For this one, Paris Convention is 1883, but this Paris Convention after 3 years it came is mainly for literary and receiving works. It has 38 articles, mainly for, it's with 120 countries as a member. The most significant international convention field of protecting copyright is established by the Union. Is further, revised by the Paris Revision in 1971. It's the scope of these conventions mainly includes with it literary and artistic works produced is mainly addressing domains irrespective of mode of forms of expression. And another important one, the conventions has been provide minimum terms of protection of copyright as life plus 50 years or an alternative of 50 years from the publication anonymous works. It also provides certain limitations to the exclusive rights such as fair use privileges, conventional recognized as a part of author exclusive economic rights. It's a moral right of author. So you look at here, World Intellectual Property Organization, the Berne Convention, which are the countries is mainly is focusing on this map of parties to the convention. You see like here, even India, you see Pakistan, India, Nepal, Bhutan, Bangladesh.
Dear participants, kindly wait. That's a technical issue. Sir will join now.
Okay, sorry for the inconvenience. Am I audible, sir?
Yes, sir, you're audible, sir. You're audible.
Okay, okay. Sorry. Okay. Where I like.
Yes, sir. Screen is visible, sir.
Yes, thank you, sir.
The screen is visible.
Yes, thank you, sir. So this Universal Copyright Convention is 1952. That's what the UCC, UCC. It's the alternative to the Berne Convention. It has revised in 1971 in Paris at the demand of developing countries. At the same time, the special provisions allow the developing countries to obtain the compulsory license under certain conditions to translate copyrighted works in terms of teaching, scholarship, and research purposes. That's what you see here now. You can see these are special provisions in terms of this UCC has given is like uh, compulsory license under certain conditions where mainly our we are going with this of copyright out of research works, teaching, scholarship, and research purpose. So WCT, why and what are these protected? And World Intellectual Property Organization, rights organization, the Copyright Treaty, CT is a special agreement under the Berne Convention that deals with the protections of work and the rights of their author in the digital environment. This also, VCT is also mentions two subjects, mainly the computer program, compilations of data. Also is another form of extent. The treaty was concluded in 1996 and entered into force 2002. So VCT is like the limited to the exceptions and articles 10 of 10 of this VCT is mainly incorporated the so-called three steps. Test determine limitations, exception provided. 92 is mainly you see the contradicting states may devise new exception limitation in appropriate to the digital environment. The extensions of existing limitation and creation of new ones is allowed if the conditions of the three-step test are met. According to this WCT, as a duration is mainly in terms of protection at least 50 years for any kind of work has been given under this, thing. This is also another further thing I just wanted to give. Now will be like World Intellectual Property Organization is another important one. Even that's what I said in the beginning when we are starting itself. I told the website WIP website. You can get many of informations about the patent, even copyright, trademarks, designs, all those things. You get the information. Even the we can get clarification over this, WIP also. The convention established the WIP was signed at 14 July 1967. The WIP has been designed as a specialized body of United Nations and also act. Uh, just a minute. Complementary body with the World Trade Organization so far as promotion protection of IPR concern. So World Trade Organization is another important one dealing with when it's come to these IPR also. And it was observed that TRIPS is mainly in that agreement was framed. Agreement was first time created multilateral framework for enforcement for the IPR. So far left to the nation state to carry out the declaration under the national law. It's a mandatory agreement attached to the World Trade Organization. Every member of World Trade Organization is required to observe the provision of TRIPs and provide minimum level of IPRs in their national laws. The failure to comply with the minimum prescribed requirement will entail the provisions for World Trade Organization. That's why we see even every country might have this IPR. When you go in the India, we have IPR is like you can see even separately maintained by the ministry, the department. We have separate department for this IPR. So this IPR it has mainly covered with the copyright related trademark, geographic indication, industrial design, patent, layout design, protection of unflown information. All this is all the IP for each and everything we have it in in countries also have a separate even we have except the protection of undisclosed information. Remaining all the six we have separate acts. We have it in India. So relevant legislation, that's what we are going to see now regarding this Indian Contract Act 1972, Competition Act 2002, Foreign Exchange Management Act or Copyright Act 1957, Trademark Act 99, and Patent Act. We'll just see what are the importance about these legislation, then move to the technology transfer. The relevant legislation. First one, Indian Contract Act 1872. This is mainly the foundation legislation encompasses all phases of the contract within India and laying out the essential element for valid contract, such as offer, acceptance, consideration, capacity of parties. It also addresses the issues like breach of the contract, remedies, and enforceability of the contractual terms. In this only we see that all the contracts are based on this Indian Contract Act 1872 mainly works. And then relevant legislation in India. The Trademarks Act 1999. This legislation deals with the registration of protection of trademarks, which is mainly distinguishing signs used to identify goods and services. We already seen about trademark. It sets out the criteria for trademark registration. At the same time, the rights are conferred by the registration and the remedial available for trademark infringement also. Another thing is Copyright Act 1970. 57. This also we have seen detailed manner. Simple way we can see this act is protect original literary, dramatic, musical, artistic works. As also grants copyright holders exclusive right to reproduce, distribute, perform, and display their work. This act also further provides the exemption limitation to the copyright protection, such as fair use. Another thing is relevant legislation in India further is a competition. Act 2002. This act is mainly promote fair and competition in the marketplace, prevent anti-competitive practices. At the same time, is prohibit agreement that restrict competitions, abuse of dominant market position, and the measures of the substantially lessens competition. Competition Commissions of India is the regulatory authority responsible for enforcing the act. Another thing is the Foreign Exchange Management Act 1999. This act regulates the foreign exchange transaction in India. It governs the flow of the foreign currency in to and out of the country and aim to facilitate external trade when it's come to payment, trade and payment. This is also further administered by the Reserve Bank of India. And then the Patents Act 1970. This also governs the protects the enforcement of the patent rights in India, as well as the patentable, which are the things which the inventions can be patented, outline the process of obtaining the various patents, the establishment of the rights and obligation of patent holder, the amendment of the act, even we seen the recent amendment in 2000, the patent rules 2025 also we have seen the alignment Indian patent regime with the international standards and promote technological invention. Another thing is there are a few more acts also you can see. The IT Act 2000 is mainly electronic commerce, cybercrime and data protection. Somehow is also related with the IPR. So IPR is not only with this system we have seen, even related with this, IT Act also comes under environmental protection also related to the impact on the environment. And then sector specific regulation depending on the industry. Sector specific regulations may apply such as those governing paramedicals and telecommunications or biotechnology. Then now will we move to the important one, then technology transfer. The important one, which you are going to see the last part of this today's session. The technology transfer. Still now we see what is the intellectual property rights. Even the patent, copyright, mainly we focused on copyright. Different acts also we see. So if I am having ownership for my, even I patent, I have a copyright for my own invention or my own work, creative work. So this how I transfer the ownership to her. This was the That's what intellectual technology transfer is, the formal transfer of intellectual property or other rights to any entity to use and commercialize new invention. The technology transfer is also done after protecting the IPR, like patent or copyrights. Because once I got my patent for my own product, I my own work, I copyright work, then only you can go for technology transfer. After the process of due vigilance about the company and with the terms of conditions of licensing, then we can go for this technology transfer. What are the different types of technology? How is technology trade? I will go for the agreement. All those things we are going to see now in this regarding technology transfer. Technology transfer, the form of that this is a process by importing the form of the knowledge, skills, methodologies involved in the whole production cycle. These are also at the same time, the technology transfer is a system that encompasses the social and economic fabric of the country, and where this technology has been effectively transferred. How? The visible change from the person to production system, capability within the need, with the institutional framework, skills in terms of training, financial capacity, in terms of promotion, active support, appreciation of the natural environment of specific of country. Technology transfer is mainly disseminating information on the technologies themselves. Is another important one. Why we did have a technology transfer? An invention would have a beneficial for the public. It transfers successfully through the technology transfer and marketed. That's what the mainly one. So yeah, for example, if someone got a patent for one product, I'm only having my own product, got patent. I'm just keeping myself. Then what is the use of that patent? I can claim myself. I have a two patents or 100 patents, but that has to be useful to the public. So whatever this IPR is mainly used for having the right. At the same time, with the given based on the novelty, it is applicability also another important one. So how it can be used for the transfer and market in terms of so the technology transfer, this can be even this IPR can be marketed, and then technology transfer is commercialization is the invention provide monetary benefit to the inventor, agency supporting the invention, and the company and also country also. Say once this the technology transfer happen, is mainly the commercial purpose also will happen. So that aspect is the beneficial part, not only the benefit for both, even the technology transfer for the invention. Another thing is supporting agencies and the companies also are involving in this. This is a multi-level beneficiary also happen out of this technology transfer. How this technology transfer, the process happening? It's a process that recognizes the practical and commercial aspects of basic science research. Basic research also happening. Discovery, increase the outreach, benefit the public, and encourage the further invention. So once the further invention, also this process is this technology transfer is happening, and the technology transfer of the comprises evaluation and management of invention portfolios, patent prosecution, demonstration on how know-how, negotiation, licensing agreement, and periodic review of cooperative research agreement already in place. The part of technology transfer also involves the prosecution of the patent, which is overseen by the National Patent and Trademark Office. National Patent and Trademark Office also, you can see how this can be done. So they will be taking overseen by this technology transfer. What is the main purpose to have this? Mainly coordination, nurturing, and linkage of basic function. I told you the marketing. See here, technology transfer and marketing. So in that level, you see the coordination between technology users and developers, as well as between the researcher and manufacturer, an important element of technology transfer. How this technology transfer happening? So as a researchers can be produced, go for the patents, and then they may go for a designs of designs layout, but it's have been a help to the developers also, how this technology uses. Between that, this technology transfer happen, and the researcher and manufacturer is another important one. Even UGC also, UCC, universal, the convention also mainly focusing on in terms of, allowing the teacher, teaching, education purpose, research purpose also is mainly focusing on it. And during the coordination process, access to the relevant internal external resources for individual products and enterprises has to be enabled by participating parties. The main ingredient for moving technology from a research laboratory to a company for manufacturing and marketing is an environment that is supportive of entrepreneurship. And further, this needs to be encouraged by providing guidance, counseling, and resources for nurturing to the new technology. For linking the various components of technology, it's further required to have a catalog resources related to the business enterprising and connecting would be entrepreneur, a researcher, other technology developers to outside entity which can help in the manufacturing and marketing products. Is mainly technology transfer is mainly commercializing the knowledge, the information knowledge which have in the form of different products or like IPR. Technology trade, how this technology can be developing technology, emerging technology, and established technology. The first one is which can be the technology is a small, the beginning stage, currently undergoing in the bench level testing, which can be a small version of the technology which is tested in the laboratory. And then emerging technology is the next level. This has been, the field level tested, but lacks in the long history. It's like when it's come to market level, whether it can be not even tested. So full level history of long history, and that information about cost and how well it works may be insufficient to predict its performance across this operating condition. But established technology, it's about the technology is mainly is tested with the performance information. Everything is readily available. So this technology has been used in many different sites, and the results are fully documented, can be considered as an establishment. The basic steps in the technology transfer. The technology transfer is first one is evaluation, assessment of the invention. The second one is protection of intellectual property related to the technology. That's what. Third one is finding most suitable partner for licensing. Fourth one is the licensing to the entity. Fifth one is the demonstration of the working of the technology. The last one is as in the pilot level and the larger level manufacturing. Another important one, this is freedom to operate. Freedom to operate, we have to see. Before commercializing the product in the country or a region, we should have a freedom to operate search. Freedom to operate is nothing but is a suggest to confirm that a particular intellectual property or a technology being licensed does not infringe the intellectual property technology of another party. We have to verify this is the freedom of operate. Whether the particular intellectual property does not infringe of any other parties, IP technology. That's what you need to see. Then next one is the freedom to operate is typically the professional extensive search in the field of intellectual property. See, mainly it's not about restricted only the patents. Even we can go for like trademarks, even different forms. We can look for other. We have seen the six important, there are seven intellectual properties. So that also you will see. The freedom to operate opinion related to the patents usually include the findings on the patent search in the relevant jurisdiction and their expiration of dates. In the If the search results the presence of the valid IP address of others that are likely to impression, one can negotiate with those parties to license their IP to facilitate bringing out the Indian product in the market. So this freedom to operate is mainly help available legal actions by others. That's what we want to see. See, previous one we see technology grade, we will see, we check, and then purpose. Then the final important one before going for technology transfer, in order to avoid legal action file, because the first point you see does not infringe the IP technology of other party. So in order to Further, no need to for further any inevitable legal action by other. In order to avoid that only, this freedom to operate can be checked. And then commercialization potential is another aspect. Even they may have intellectual property. They have got it like intellectual all the aspects. They may have the patents they have. But whether the particular patent, it has its own commercial potential. That's the most significant aspect and effective technology transfer. Establishing technology prospects, the commercial success depends upon the six factors, larger upon the six factors. The first one is whether the particular one it has a demand or not. See, it must be newly improved version of existing technology or anything. Not only technology, even the how this even any work. Even if it's similar, cost effective, more efficacy is also that we focus on, and then technical development, the time, materials, and personal needed for reproduce the technology to practice and product rights to be resulting the product. That's also another important one. Commercializing the potential, we need to check into that, look into that. And regulatory clearance, the testing needed to demonstrate the product utility and safety to meet the regulatory requirement of the country in order to minimize or manage the associated risk also matter. If newly any product is coming, so we have to keep it in the IPR and then related with the regulatory clearance. And then manufacturing requirement, manpower, facilities, and equipment needed to make such product. That's also going to keep it. And market development, the plan for successful marketing. Creator for the market development, and by assessing perceived need for the product, the size of potential market, expected sales, advantage over the competing products, and the cost of promoting product. That's what we need to say market development. Another thing is financial feasibility, the development cost, production cost, operating expenses related to the sales potential, net profit, potential liabilities, and return on investment. These are things we need to keep it in mind. So there are six commercial because of technology. Once you transfer how this technology transfer the IPR can be commercially potential for the particular one party. That also keep it in mind. And then technology transfer agreement. So technology transfer agreement, once both parties agree, then only this technology transfer agreement will be happen. Technology, the transferring intellectual property from one organization to another is done through the technology property transfer agreement. That's a thing between the two parties. It's mainly used to refer to the wide range of contract that is meant to cover the procedure for transferring ownership, a right to use a certain technology from one party to another. It's not only the entire ownership. It can be certain ownership can be given to the part of the entire technology certain technology can be given to the technology transfer, and then technology transfer agreement further one. It's an essential tool for making sure that new innovations are produced via collaboration between various academic and commercial organizations in the life science industries that are currently ones are utilized effectively. And next, now move to our aspect like it's compared, academic institution, how this measures successful in technology transfer. We almost come to the end of today's session. I want mainly stress about like why we're going to have a technology transfer in terms of our academic institutions. The success in technology transfer can be categorized as a numerical and non-numerical. When it's come to numerical measure, it's further is divided into early numerical and later numerical measures. So first one is early numerical measures. Is about include number of patent filed. Say, even the academic institutions, such as even the colleges or universities, research institutions, can be filed patents, even license agreement executed, and the new companies also formed, can be formed. But it's called the early numerical term. Once number of patents filed is matter. At the same time, number of patents can be granted out of this number of patents filed that matters. That's what we called as like, that further. Once you're filing, after that we got grants from the, patents is buying, license agreement will also happen. But after once, how we are going to materialize or commercialize this even IPR, since I intellectual properties. For example, the patent. Once you got the patent, whether we are going to go for marketing, that will happen through the technology transfer. So that's what we call as a later numerical measures that includes revenues from the license fees, royalty, cash from the equity investments paid to the academic institutions, and the number of products successfully introduced to the market. That's what it's mainly in terms of how much revenues we got it out of this patents and through the technology transfer once the patent has been came to markets. How that's what how this academic institution benefit out of this. Another thing is non-numerical includes it's about the university ability to retain entrepreneurial faculty as well as students, the scholars. How these universities or institutions are producing through this. That's what called as a non-numerical includes technology transfer, university ability to retain entrepreneurial faculty, attract outstanding graduate students to contribute to the institutional reputation for innovation, arguments, its research program through interaction with the private sector and enhance its reputation for providing highly trained students for the industrial workforce. And then the success, main success is measured of any academic institution in terms of technology transfer. So demonstrated by the impact of products having lives in the general public. So another important aspect, that's what I want to say. So whatever this IPR should be helpful for the public purpose. So one of the different parts, even you see the Tamil with the different gadgets and using laptop, mobiles, we are using. This is using for the public purpose. It's a intellectual properties. How it's utilized. So this like that. Even now, if you see nowadays, if you see even the people are like different institutions, they started filing, they're getting the granted patent. Once you got a patent, what are we doing? So whether it coming to the market, that is questionable. How much is effectively is marketable, is usable, applicability to the ground, reality. That also we need to keep it in mind. That's what is the last point. The success also demonstrated by the impact of products and the lives of general public. Another thing is the benefits of technology transfer ever made by R&D institutions, research and development institutes. The license of innovation by academic institutions, a research and development institute, a hospital may collectively term as academic technology transfer. Further, we want to see academic technology transfer. In such technology transfer, it's also called as maybe a substantial amount of money to the Indian economy and increase employment opportunity. So that's what this academic technology transfer, it may boost our Indian economy. In not only Indian economy, even any country, this academic technology is transferring, boosting their particular country economy and increase the employment opportunity. Because a new invention is coming to the market, whether it's useful. See, you see the mobile phone, for example, mobile phone, even the beginning now, how is like me evolved. It's a new invention zone. Different inventions happening, for example. And then different technologies. Then how it's useful? It's one or the other. It's useful for the country as well as individual as well as useful for one the technology transfer in terms of transfer happening the market to come to the market whether it's substantial amount it's creating new employment opportunities too. Again, further, it also contributes to the spanning of the new businesses, creating new industries and opening new markets. Now you see, 20 years or 30 years back now, what are the new inventions and new creative industries have been come to our market? Is everything, it's from the human minds, creating minds, and say about. So that's what the technology transfer is mainly. Some certain things are happening from the, hmm, R&D institutions also another important aspect. So most importantly, the successful technology transfer leads to the new products and services that improve every individual quality of life. For example, this is for example cancer treatment to foster gadgets, environment-friendly devices, etc. That makes the way, yeah, that makes the way we live in work better. The next, everything has a pros and cons. What are the cons? That are the challenges in technology transfer. The technology transfer, it has a substantial growth opportunities for India, but encounters multiple obstacles. I mainly focus in Indian aspect. So what are the the challenges? Technology transfer in mainly in India. Intellectual property protection concern. The foreign firms remain reluctant to share their top level technology with India is mainly because sometimes, I'm not generalizing here, I'm not generalizing here, but just saying, even sometimes how much effectiveness of IP enforcement mechanisms there. Even I told you, many of us having a patent we have, but how much it's like we are using into the markets, the ground for the public. Another thing is regulatory complexity. The advanced technology used in, for example, paramedical or manufacturing require a high licensing fee, which puts them out of the reach many Indian companies. In terms of medical field, high licensing costs. For example, the advanced technology necessary for in terms of medical manufacturing one, substantial licensing fees, creating financial challenges for many Indian companies. Another thing is lack of skilled workforce. Even though the successful technology adoption depends upon the trained personnel implementing develop transfer technology, even though we have a huge number of the huge human resource, but how much skill workforce is we converting into the skill workforce for the technology, it's still questionable. But further, there are various acts we have that we'll see. Data privacy and cyber security risk. The mitigation of cyber security risk in digital technology transfer, demand, restrict completion of the data protection, such as Digital Personal Data Protection Act of 2023. Yeah. The future of technology transfer in India. Yes. The future of technology transfer in India, we see how we are going to see like this technology transfer happen for the future. Indian government continues its efforts to develop technology. Even the previous one challenges we, in order to overcome these challenges, even from the government side also we see that a lot of efforts have been carried out from the government in terms of the transfer friendly and the technology transfer friendly environment. See the, for example, Make in India, PLI schemes. So you see PLI schemes, the Protection of Linked Initiative Scheme is launched in 2020, is mainly for the main aim for strengthening India's manufacturing possibility by offering financial incentives to eligible companies based on their incremental sales. The scheme initially targeted three sectors, and over time, it has expanded to include 14 sectors ranging from the electronics to textiles to automobile and food processing. There are different levels also in the government side also there are effort has been taken. This what they see that's on foreign investment and post local manufacturing. Foreign investment in local and post local manufacturing and technological independence to Make in India and PLA schemes. India's national intellectual property rights policy. India's national intellectual property rights. So we can, you know, You can get it this national intellectual property rights policy that's mainly aims to fortify patent enforcement mechanism and to enhance business operation conditions. Technology driven startup receive additional support through the Startup India initiative and to acquire utilize the foreign technologies. Another important one when it comes to fusion technology, the advance of technology transfer in India rely heavily on increased commitment to R&D activities and better funding for innovation and efficient regulatory approval processes. Another important when it comes to this, the maximization of the technology transfer advantages in India depends on reinforcement IP protection, international collaboration, and workforce capability improvement. So these things we see there are future for technology transfer. It mainly depends upon like how much we are putting effort. Even many of us, I think most of us here from the academic institutions. So our airport, like how the ultimately this how we are going to take care of our intellectual property. Our creative minds utilize the intellectual property into convert into intellectual property and go for intellectual property safeguard to get the intellectual property rights in terms of patent, other aspect, copyright. So this should be useful for the public. So before going to that, I just wanted to say takeaway points for the session for today. We mainly focused on today. I just give overview about the today's session. We started with about what is property, intellectual property, what is property and intellectual property. Then we move to the types. These things you always remember: copyright, patents, and trademark. For when it comes to academic institutions like people like us, is mainly going for patent as well as copyright. These things mainly we are mainly dealing with. Even I hope majority of us mainly focusing on this pattern as well as copyright. These keep it always remember today. Here's property rights, the importance, and then copyright we have seen. The importance about copyright is about copyright given to the life of author plus 60 years. And when it's come to trademarks, simple, subject renewal for 10 years, industrial designs, and then yeah, this is patent.
Sir, you are muted, sir. Sir, you are muted, sir.
Now,
Ah, yes, audible.
okay. So the patent we are seeing today, it's about 20 years from the date of filing the patent under the Patent Act 1970. Conditions always remember the novelty, non-obviousness, industrial applicability. This ministry always remember when it's come to intellectual property right. The Department of Promotion of Industries and Internal Trade under the Ministry of Commerce and Industry. The office for this Office for Control of General Patent, Designs and Trademarks. A separate office for Copyright Office for copyright. For it's come to copyright. Copyright is in the three forms: C, originality, literary work, and dramatic, music, or artistic for individual. It's about till the year death plus 60 years. In case of the organizations, it can be 60 years period from the counted from the date of publication. For performance right, about 50 years from the date of performance. Of hardcopy, it's about 25 years from the date of making broadcast. Can be reproduced. Extra bits, moral rights. We have seen this about Amarnath Sehgal versus Union of India. So if you're interested, you can go and search about this particular case. You can get to know about like interestingly how much the intellectual property is. It's called the copyright also works. Also penalty. You get it's a well-known. It's a well-known case. Infringement. And I think infringement. For infringement, we have to always remember this thing, answering, asking questions to the students, writing in the semester for semester exam. You are reproducing from the textbook. That cannot be considered as a infringement. These conventions like International Instrument Party related to the IPR, intellectual property rights, Paris Convention, Berne Convention, Universal Copyright Convention, WIP, PCT as well as WCT, TRIPs, SC. Another thing is these acts, which will be we cover technology transfer. Finally, we focused on the technology transfer. Technology transfer is mainly for the public purpose, converting into successful through technology transfer and marketer transfer for the commercial invention provides monetary benefit. That's what very important. Technology transfer in terms of a monetary benefit to the inventor, agency support, supporting the inventions, or the company to the country. So ultimately, we are focusing on the country. So freedom to operate is important when you're going for technology transfer. Always we keep it in mind. We have to look in for another thing is commercialization potential. There are 6 factors: demand for technology, technical development, regulatory clearance, manufacturing requirement, market development, financial visibility. Another thing is the technology transfer agreement also we are seeing. And then academic institution, last we have seen the academic institution, whether the how much we have a role, huge role when it's come to IPR as well as technology transfer in terms of the products. It should be has a impact in the products to have a lives of general public, and then R&D, and then these are challenges also we have seen to overcome this. We have certain things initiatives have been taken by the government. With the help of the government, we can also focus for intellectual property. Now, I think with this, I'm stopping here. If you have questions, you can ask me right now, sir.
Yes, thank you so much, sir. It's a beautiful presentation. And dear participants, we have 12 minutes of time. If you have any questions or any kind of appreciations, you are most welcome to.
I hope I justifies today's assignments. Hopefully,
Okay, so thank you so much, Dr. Arul, sir, for your beautiful presentation. And dear participants, successfully we have completed our seventh day. Still, we have 5 more days, and tomorrow we have a class from another faculty,
Sir,
Dr.
can I
John.
ask
Ah,
next?
yes, yes, please ask, please ask.
Sir, I wanted to ask something about the infringement that you talked about. That if we are recording someone's performance that is being held in an organization, so then if suppose people go to concerts and then they record it and then they post it and then make profit of it, then are the people making infringements?
no, no. And that's what I clearly said. That cannot be considered as infringement.
But if
This
the
happened in
party,
the public place.
okay, if it's in the public place, it's not infringement.
We cannot consider it as a no. I consider it as an infringement.
Okay, sir.
That's what is clearly is mentioned in the Copyright Act.
Okay, any other questions? Till we have 10 more minutes time. Okay. So dear participants, we are having our another international faculty development program uh, on what was that teaching pedagogies and research. Actually, we scheduled in the month of May, and many people are started asking the link now itself. And we have to finalize with the collaborators first, and then we will send you the link, brochure, everything. And meanwhile, if your department or if your college or university is interested to collaborate with us, do let us know. We are ready to collaborate with you for this international event. It is an international event with international resource person. We will come to your institution for online. Offline also we are coming, and so we bunches of people ready to travel to entire part of India in the month of May. And FDP is compulsory for all the faculties, right? So we are doing it for the second year. This is our second year we plan to do. And so if you're interested, if any of your faculty is interested to join with us, please let us know. We will join this event together and we will reach our goal accordingly. And this entire May month, we are having this international faculty development program. And in the month of November, we are going to Sri Lanka. Now, Sri Lankan authorities coming to India as a part of faculty development program and faculty exchange program. In the month of November, we are going to Sri Lanka as a part of faculty exchange program. So a lot of things to be done from here. It's not about organizing one event or two events. We are organizing sequence of events for the development of the students community as well as the faculty. Okay. Participating in FDP will give you 1 mark if you go for the interview. That also credit based. So we are maximum running our we are maximum to maximum we used to go for more than 30 hours, which will give at least 2 credit to the concerned participants so that they will get some amount in their hand. Maximum marks, amount in the sense marks in their hand. This is what we have decided. We have prepared everything. We have finalized with the resource person also. We are about to get with the collaborative institutions. We are seeking collaborative, particularly from Delhi, Punjab, Kashmir, because we thought of converting into this event as a traveling and living. This is what we have decided. Meanwhile, any other universities interested to collaborate also do let us know. For offline collaborating institutions, there is no fee. You have to take care of our accommodation. 5 people will come. One international resource person, 4 national resource person will come to you, and we will stay there for 2 days. And we will do all the protocols for the offline sessions. We will bring our kids. We will give certificates. Everything we will take care of you. Once the accommodation is given to us, and rest of the things they will be taken care of us. This is what we have designed for. Anything else, if you want to ask, you can ask us directly in the group. We have kept everything open only. Meanwhile, tomorrow is the 8th day, so of course we have crossed half of our bridge. Tomorrow, Dr. Janaki, she is working as an associate professor and senior faculty in the Department of Forensic Science in a great university, Kalasalingam Academy of Research and Education, Kalasalingam University, which is located in Virudhunagar, Madurai, Tamil Nadu. She is also from Tamil Nadu. After a long time, we have given more importance for the southern side because many people have give us a concern. So we also want to work as a resource person kindly take care of us. So we have taken them, and she also an expert in the field of uh, research, publication, patent, as well as law. So such a dynamic resource person tomorrow will be there. Please do participate and please be not only participating for certificate. If you need certificate, Abhi Bolo, I will send you tomorrow itself. So certificate is not a matter because we are not commercial based, not certificate based. Learn something. The ultimate aim of keeping this event from 6 o'clock to 8 o'clock is okay. You'll be having some free time so that you will learn something. I know that many people won't listen, but few people, right? When I was used to take class, many faculty used to say, "Me sir, when you are taking class, we are taking notes. You talk slowly, sir." So I have changed my lesson because of my what was that? I have changed my teaching attitude because of the feedback. Like people are taking notes. So this is what I need from you people also. Please learn something because in the name of patent, in the name of citation, in the name of IPR, many agencies started developing, right? And many fake publishers also started developing. Why? Because no, they are using our knowledge and they are using our ignorance and then they are looting money from us. It is we can't blame anyone since we are uneducated in this field. Even though we are educated in research aspect, in many field we are uneducated. So taking into consideration only, we are taking a lot of efforts to give you a great class. This is what the concern mean. Okay. So thank you so much for your active participation for the day 7 and tomorrow we have 5 more days. And last day we will have 3 hours. No, nobody asked me, sir, how come 12 days class became 25 hours class? Because last day we will be having 3 hours of class. Okay, last day she will be taking the concerned resource person told me, sir, we need 3 hours of class. So she will be taking the class for 2.5 hours, and remaining half an hour we will keep it for the validity session. Altogether, the entire research course has 25 hours, which has more than one credit course. This is what we have planned, and this certificate also you can show for your interview purpose, cash purpose, promotion purpose, appraisal, wherever you want to show, you can show. This is certificate is also a valid one, and we will give you the soft copy certificate for verification purpose. Hard copy also we will send it to you to your registered address. This is for your kind information. And thank you so much. Good night. Once again, we will see you tomorrow.
Good night, sir.